It is exactly 8 o'clock Central African time. You're watching The Full View here on the SABC channel 404. It is a Thursday, and that means it's time for On the Record. So, what is the best practice for questioning complainants in cases of sexual abuse or even rape? Legal experts seem to differ on what is permissible and what crosses the line. When is a murder suspect deemed a killer? And is it after a conviction or once they have been charged? And how may we in the media report on these cases, especially when they are televised in the age of social media? In recent weeks, the defense counsel for rape-accused Timothy Omotoso has faced outrage for the cross-examination of Cheryl Zondi, who has accused the televangelist pastor of grooming and sexually abusing her since she was 14 years old. It's also brought into sharp focus the debate about the rights of the accused and the complainant and how these cases are reported on. On whose side is the law anyway? Well, welcome to On the Record. My guests are media strategist Lance Classen, media lawyer Okryrebea Ampofo-Anti, and labor lawyer Natasha Moni. Good evening to the three of you, and thank you so much for joining us for our On the Record discussion. I mean, the first place, let me start with you, Okryrebea, in terms of what is permissible, what is not. Let's start with the basics of legal reporting when it comes to these cases. We've seen, of course, the precedent that was set in the Oscar Pistorius trial, right? Absolutely. The televising of that channel, that trial rather, a special channel for it. It's opened up a whole can of worms, has it not?
Absolutely, Bongani. You know, we really are in a new era, and that's quite a scary thing for a lawyer to say, because lawyers like consistency and we like things to be the way they've always been. But recently, with the rise of social media, with the rise of televising, the courts have been challenged on the issue of allowing cameras into the courts. And so that's why we actually saw the Oscar Pistorius case happening. And it was almost like our O.J. Simpson moment, right? And it's cracked the field wide open. But it really creates a lot of challenges for both the media and attorneys who are in court, and indeed for judges as well, because it raises the very question you've put about what are the parameters. So first of all, we now know that at least we're in an era where televising of the courts is no longer a no-go era as it was in the past. But the question then is, how far is too far? And what about the rights of the complainant? I think what's been fascinating in the Omotoso matter is the fact that this complainant has been brave enough to actually agree to allow the media in. Because if she hadn't, then it wouldn't have been possible for the media to go in there. Because the Criminal Procedure Act actually says that in a case where you are dealing with a sexual offense, the court is automatically closed when the complainant is testifying, unless the complainant accepts that the court can be open. So she's actually done quite a brave and quite an unusual thing to agree to allow the media to be in there.
Now, I mean, we'll talk about the sub judice rule in a moment or a little later on in our conversation, but it also raises the question around how courts may be swayed by public opinion, because, of course, we've seen that arise in the case. Indeed, the defense counsel asking the judge to recuse himself because the spotlight has been so heavily on what happened in court, particularly under cross-examination.
No, absolutely. And the interesting thing about the sub judice rule is that it's really become a bit of a relic. The sub judice rule is a hangover from systems where there are juries, where you have ordinary members of the public who are not legally trained and who may be influenced by what is reported in the media. Now, in theory, judges are not supposed to be subject to that kind of influence, right? Because lawyers are trained and we understand.
And they go with what's on the record.
What is on the record, not what is in the media, what is in the newspaper, etc. So the sub judice rule at the moment, there's a very interesting court case, the MIDI TV case, where the court effectively kind of took the heart and soul out of the sub judice rule by reinterpreting it to be in line with our new constitution and the right to freedom of expression. And what the court said there is that unless the reportage in question will actually pose a real risk of undermining the administration of justice, there's no limitation. So the sub judice rule, for all intents and purposes, is largely dead.
Right, we'll come to that in a moment. Lance, of course, let me bring you in as the media specialist on this panel. I mean, when you look at these cases, right, there are many who would look at them and say, we in the media haven't covered ourselves in glory in terms particularly the issues of race, the issues of gender that become also a factor in who is named and who is not?
In fact, I think we've covered ourselves more in confusion, because this is where the law and the right for the public to know has come really in real conflict. Let's take a really good example of what happened with the alleged gross rapist. So this young man was supposed to appear in the court on Tuesday. It breaks on the weekend that who he is within social media. So it leads to an absolute Twitter war out there, because I'm saying that, okay, there's a law, I might not agree with it, but I have to adhere to it. And then I went onto Twitter, and it was a total onslaught. Insults were being thrown left, right, and center, and I was just restating the law. And the real issue is that we in traditional media or traditional institutions have to learn that that social media has changed everything. But we also have to explain how has it changed everything. It's made everything emotive. That level of let us wait, let us think, and has disappeared. For example, when we grew up in newsrooms, Bongani, it means that we go through an editing process. There's a level of debate, there's a level of discussion, there's a level of toing and throwing that takes place.
There's no such digital age. People want to be first. People want to get as many retweets, want to get as many likes as possible. But let's come back to the media in terms of the profession itself. Race has been a key issue around how these things are publicized. There's been this idea, there's been an idea that, you know, where the perpetrator or the alleged perpetrator is black, we happily name and shame, but perhaps are a little bit more, what is the word I would say?
Reticent,
just careful, right? We're a little bit more considerate in terms of what the rules mean when the accused is not black.
So this is the debate that got on in social media. Can you give a quantifiable study? Or is it just an opinion? So, and most people will say, no, let's get this. So they give two examples. The first example, they'll give Zuma on the rape case. So, but he gave an interview to Sunday Independent before he appeared in court. So he takes it off the table. The second one was that where the race suspect was being named was the Mandela's grandson at the rape in the restaurant. Then it was argued that was in the public interest. How's that in the public interest? It's interesting for the public, but not necessarily in the public interest. And so in newsrooms, there's this great debate and tension. Even in SANEF, there's no total agreement on this. So when people say, well, it's good for X and it's good for Y, is it good for everybody? Did you do a survey? Is there a study? Is there substance to the? I would accept.
So you don't buy the argument that there's more circumspection in the media when it comes to the race of the accused person?
Let's take the Verulam rapist, where this man raped his daughter and was on 900 counts. We didn't name him because we have to protect the daughter. So before people tweet, they have to take it into account. What am I doing? Am I putting my point of view and then looking for facts to support my point of view, or am I letting facts support the case?
Natasha, let me bring you in. You're the labor lawyer, because of course all of these factors, whether it's the media that gets it wrong or even it's out there on social media, have real consequences, including of course when it comes to people's employment and that sort of thing.
Absolutely, and what people can do when they find something that has been going on in the employment sphere, they can report it using the Protected Disclosure Act. But I'd like to come back to what Lance has said. You know, the courts have held that if you're going to make a protected disclosure, you cannot put it on an SMS, for instance, or tweet it. You have to perform that protected disclosure via an attorney or via the media, because the media has thresholds, boundaries. They know what it is that they're doing. Whereas the SMSs, your WhatsApps, your tweets, are not subject to some form of media policy. But
they can be considered published material. I mean, the fact that you possess this information, the fact that you may disseminate that information in closed spaces doesn't necessarily mean you can get away with it if you are charged.
So you will not be protected then. If you blow the whistle and you do it outside the parameters of the Act, then you will not be protected if you suffer some form of detriment, occupational detriment. And that is what people who blow the whistle must be very, very sure about, that they're doing it in the correct way.
So let's take the Malusi Gigaba video that did the rounds at the weekend. There were many calls in many sectors that this man needs to be dismissed by the president. This is enough evidence. Let him go, Mr. President. Not quite.
Well, Malusi Gigaba is fascinating because he's getting into trouble quite often. And this is just another one of those. But he's bringing the government into disrepute.
Based on that video?
Based on the video and based on other things that he's doing. Well, not on the video. Everyone can have sex with a partner, you know what I mean? But it's not particularly on that video. It's on other things that he's doing. But he brings the public into disrepute. And that is what I would dismiss him on. I wouldn't dismiss him on the fact that this video went viral.
All right, we'll come back to people who are being dismissed because that's been that kind of day. Okryrebea, let me come back to you in this conversation. Right, we know these trials are often televised now. As you say, the landscape has changed. Talk to me about the fact that, you know, journalists are, because they're trained, because there are parameters within which we must operate, we tend to be more circumspect. Is there a point to that when social media is often quite ahead of us in terms of how these things are discussed in the public domain?
Well, look, I mean, that's quite an important question, but I guess in some ways it boils down to the question of ethics, right? And to whether or not you are willing to keep your head when the whole world is going mad, effectively. The reality is that journalists are professional and that you are subject to codes of conduct. In the print media, there's the press code. In the broadcast media, there's the Broadcasting Complaints Commission. And quite aside from that, journalists, generally speaking, so somewhat less and less so these days, but generally speaking, are part of media houses and part of corporations that tend to attract lawsuits because there's a belief on the part of whoever it is that you've harmed that there's money back there that they can get by
there's
suing
money behind the journalist.
There's money behind the journalist. So the idea that you and I, for example, you as Bongani and I as Okryrebea are equal when it comes to the consequences of our dissemination is not actually factually correct, because I might tweet something and my 200 followers might retweet it, but you've got a heck more than 200 followers, and if you tweet something, people think that you've established the facts behind it as well. So journalists do have to be more careful. Explain
the concept of something that is published or maybe deemed as published, not necessarily being limited to the professional media.
Well, and this is an absolutely key point. Thanks for raising this, Bongani, because I think there's this misconception that I can be a keyboard warrior, I can be behind my Twitter account and my Instagram account, even on an anonymous basis, and that it doesn't have the same consequences as when a newspaper publishes something from a legal point of view. That is completely wrong. Publication for purposes of defamation, for purposes of breaching someone's privacy, etc., is certainly something that can happen when you put information up on your Twitter, when you put information up on your Facebook page, etc., when you put information up on your Instagram account, via Snapchat, or any other social media or online platform.
If another pair of eyes has seen it, it's considered published.
It is considered to have been published, certainly for purposes of a defamation claim.
Yeah.
So once you are out there saying whatever you're saying, even if it's not on social media for that matter, even if it's something that's being disseminated verbally, you could potentially be the subject of a claim. The reality, though, is that from a risk analysis point of view, it seldom happens. And so because of that, people get comfortable. And they think, well, Malusi Gigaba's not going to come after me, right? I mean, who am I? So I can say whatever I want.
Tell that to one or two journalists.
But this is the difference between a journalist and an individual. So individuals are saying this to themselves, I can say whatever I want. And if journalists, going back to your original question, why should journalists behave differently, is that you're not just whoever. The reality is that if you say something, people take it seriously. But you have a reputation and credibility that backs what you say, which is why politicians come after you.
But there's a clamor for naming and shaming, both in terms of the headlines, and we'll look at that in just a moment. Before we go to break quickly, Natasha, let me bring you back in. I mean, let's talk about cases of sexual harassment, for example, right? What happens in terms of what one is able to disseminate? If Lance tells me something, perhaps in confidence or in a closed WhatsApp group, what do I do with that information when it comes to naming and shaming, because there is a real pressure, particularly from social activists, that these people must be exposed.
Well, social activists that are not journalists, you expose that when you believe that you're doing it in good faith, and you're doing it because you believe that the employer has done something wrong, either criminally or a misconduct of some form. That is when you're protected. If you don't go through the steps of looking at the information and getting assistance from an attorney or from a journalist or from your employer, and you name and shame, or you tell it to somebody and they name and shame it, you do so at your own risk. And if you get fired because of it, it's an occupational detriment that you cannot be protected from. You can be protected and claim an unfair labour practice dispute and try to get patrimonial and non-patrimonial damages at the Labour Court for an unfair labour practice dispute and an unfair dismissal, if you follow the rules in terms of the Protected Disclosure
Follow
Act.
the rules. That's something we all need to do. We'll talk about sources and how this comes into play for the media. Stay with us. Of course, this is On the Record. We're looking at reporting around matters before court where people have been accused. How does the system work? Where do the boundaries lie? Particularly, of course, in the age of social media. Stay with us.
The only way to pour the perfect beer, this professional barman would tell you, is into a glass tilted at exactly 45 degrees. Oh, bless you. Bless you, sir. Bless you again. Well, we'd say the perfect way to pour a beer is at this angle, straight into your mouth.
Buy 2 6-packs of Castle Light Handies for only $109.99 from Tops at Spar.
The great bank heist. It was brazen. It was quick.
One thought we're perhaps looking at figures much, much lower. Right. It's almost 2 billion.
It was shared amongst very greedy VBS executives and politically connected individuals. You are listed in that report. Did you steal money?
The narrative that they're trying to create is proven wrong by Advocate Mtao's report himself. He said in point 59 that he could not find a definitive wrongdoing, anything factually.
The misleading information which Daily Maverick has is deliberate. It's part of the whole propaganda machinery. You can challenge this poly fanfic to bring us the so-called evidence that I received 10 million. It's pure insanity.
Is there any prospect whatsoever of saving VBS?
We are not as confident as we were when we started the curatorship as to restoring the bank.
The bank is in a hopeless situation and it cannot be saved.
Right, you're watching On the Record. It is a Thursday. We're looking at reportage around criminal matters, both in terms of what the official media may or may not say, and indeed even social media. So you also come into this discussion. All right, Lance, you are the journalist on the panel. I mean, listen, everybody wants to be first. We're living in the era of breaking news, and what that means, often there is sensationalism. I mean, let's take a very basic one, right? When may a murder suspect be called a killer, for example?
After the court case and the judge convicts him. It's that simple. Other than that, it's all alleged all the way up to that.
So even if somebody has died at my hands for whatever reason, I mean, I may have an explanation of self-defense. I have killed this person. Am I not still a killer?
Then it might be a culpable homicide. It might be another charge, but it might not be murder. For example, let me give you an example of culpable homicide. Let's look at that there was a taxi in the Western Cape where the driver went over the crossing. The train got hit by a train. The driver got out, but the children were killed in the taxi. That was taken to court, and he was found guilty of murder, but on appeal. it was found that it was culpable homicide because he didn't intend to kill the person.
Sure.
So that's where it comes in. But also,
so killer is on the same level as murder, for example, murderer. No, Okryrebea?
Look, I mean, I think the important thing here from a defamation point of view, because that's what ultimately the consequence would be, right? Either you're going to be taken to court for defamation, or you're going to be taken to the ombudsman or BCCSA accused of defaming somebody, harming their reputation. The real question is the context and the language that is used. And this is what I always say to journalists, is that you need to be very conscious about which word you choose, right? Because you're choosing that word because it has a specific meaning. You are trying to communicate a specific understanding to your reader or to your listener. So the word killer used is a very emotive word, but it also depends on the context, right? You could write it or you could speak it in a manner that makes it clear that you are referring to the act of killing versus the judgment of guilt of being a killer. So it's really about the art of the words that you use.
All right, let's talk about the words then. I've got a couple of headlines, and we can just look back on our video wall here. They're coming up on the screen. We'll look at those headlines in a moment. But, I mean, one of the other things that people find difficult navigating is the legal jargon that is often used by reporters. We'll come back to the words. Our system keeps changing. Let's look at these headlines. Raped by the system. Police neglecting to collect evidence kits from hospitals. Is that fair game?
That's fair.
Yes.
Yes.
It depends on what's written in the article.
The media lawyer says, well, caution, caution, caution. All right, Oscar Pistorius, they're punching holes in detectives' testimony boosts athletes' bail bid. Defense gives Oscar hope. That one?
That's fair because it's not making a judgment. It's alluding to something.
All right, let's move on to the front pages there that you are seeing. Anything to object to there?
Cold-hearted killer? But that's after the conviction, right?
Yes, because
that
he's
was
guilty.
when he was about to be sentenced. So that's okay.
So once you've been found guilty of murder, that is fair game. Cold-hearted killer. All right, those are some of the headlines in the front pages that we are seeing there. Now let's come into some of the jargon, because quite often we as journalists assume people understand what we mean. We've already spoken about the sub judice rule, for example. Let's talk about there's always an argument about, is it prima facie, prima facie? Firstly, how do you even say it?
Prima facie. So in Latin, a C is always pronounced like a K. Facie. So it's not facie, it's facie.
So that's out of the way. Prima facie, what does that mean?
Prima facie means that basically on the face of it. So on the face of it, or at first glance, there appears to be, for example, evidence. So a prima facie case, and I think this terminology practically became a swear word at the time when the charges were withdrawn against the former President Jacob Zuma, because a press conference had been called and a statement made that there's a prima facie case against him, which means there's evidence which suggests at first blush or on first glance that there is something to answer. But of course, it's yet to be adjudicated.
Natasha, no doubt non-disclosure is something you've dealt with in your time as a Labour lawyer. Can you get into that?
All the time. And non-disclosure is very important because that is how us Labour lawyers are able to get settlements and able to get where we want to go in terms of labour law. So non-disclosure is you're not disclosing a settlement, or you're not disclosing confidential information or competitive information within the workplace. If you disclose that which you have said that you will not disclose, there's normally a penalty, and those penalties can run into millions. So it's important when you're signing a non-disclosure to understand the context in which you can and cannot disclose the information.
Can you then say that you were bullied, for example, into signing a non-disclosure agreement, and now you've changed your mind because actually, particularly, I mean, let's look at the context of hashtag #MeToo, for example.
In law, you can only be bullied if I stick a gun to your head, or I say to you, I've kidnapped your child and you're not getting her back until such time as you sign that agreement.
I mean, it's not quite South African law, but an interesting case that I can think of is the Cristiano Ronaldo matter, the accusations there. That accuser says that she was bullied, she was pressured into signing a non-disclosure and has changed her mind.
Look, in South African law, especially in labour law, there are often people, especially employees, who come and say, I was forced to sign this. I was forced to sign the settlement agreement. I don't want to settle any longer. And it doesn't hold water. 9 times out of 10, it does not hold water. Yeah. The CCMA doesn't have any jurisdiction to hear the matter, and the matter has to go to the labour court to be ventilated.
All right, we're quickly running out of time. I want maybe your final comments from all of you, from each of you. Whose law, whose side is the law on anyway, particularly when it comes to issues of protecting the rights of the complainant and the accused? Where is that sweet spot? Natasha, I'll start with you.
I really don't think that the Protected Disclosure Act works. I have seen many employees fall by the wayside either through unfair labour practice disputes and unfair dismissals. And they're broken. They're absolutely broken by making a disclosure and the company sweeping it under the carpet. And for instance, the suicide protest in Parliament is one of them. And we're seeing more and more come through. It's a very, very real problem. There is absolutely no protection. It's like a piece of paper, like an interdict.
That's from your perspective as a labour lawyer, the media specialist. On whose side is the law anyway?
The law is on the side of the person with the most money. It's that simple. Who's got deeper pockets, who can take it further, that's the person. Because sometimes the law can just grind out an individual if we've got a big, if they're at war with a big institution.
Do we in the media help in terms of perceptions around that?
That's yes and no, eh? Yes and no. So South African psyche is this, we like a hero but we love a victim. So if you're the victim, it plays into our hands. But also what we also have to watch when coming specifically to issues of social media, just reciting stuff out and saying this act says this is not good enough. And that's what I found out in my interaction with the DOS, in that I went and put out a piece of legislation out there and I got bashed for putting out the piece of legislation out there. And upon reflection, I thought what I should have done is actually should have qualified it more.
And explain.
And that's the kind of spaces that we're in. We cannot just say, well, that's what the law says. We have to explain, we have to understand, we have to tease it, we have to take social media deep.
But because the emotions run so high, Okryrebea, when it comes to these matters, there is a perception out there that quite often the law is on the side of the accused a lot more than it is on the complainant. Is that something you agree with?
Well, look, from a criminal law point of view, that's a debatable matter. The reality is that if any of us today were to be accused of something, whether we'd done it, and especially if we hadn't done it, we would want each and every single one of those protections to be available to us. So I think, unfortunately, often when we analyze things, we tend to assume that we would never find ourselves in that position, and we tend to assume that the person is guilty, and therefore what are they hiding behind all of these rules for? But those rules exist for a reason. I'm not saying they're perfect. As a lawyer, I know that they can be very broken, but they do exist for a reason. When it comes, though, to the issue of the reporting on the courts, I actually think that the needle has been moving over time in terms of whose side is it on. I think that especially in our new constitutional dispensation and with the cases that have been fought over the years by many in the media, we're now at a point where we can finally see something like the Timothy Omotoso trial. 10 years ago, it would never have happened. We would have had to rely on print journalists. That's if the courtroom had not been closed to exclude them as well because it's a rape trial. So the needle is moving.
In 30 seconds, Natasha, because you're here, let me be naughty. Tom Moyane has been fired today. You're a labour lawyer. Your verdict. Good move, bad move?
It's a fantastic move. Put him outside. Let him feel the cold.
Legally, will it hold?
It may or may not, but who cares? He's out of the system. And I know that's not a very labour lawyer-like thing to say.
No, it is not.
But I would have done that first off. I would never have run an inquiry. I would have just said to him, please go and fight us on the outside.
All right, and that's how we will leave it. Thank you very much to the three of you for joining us this evening. On the record, on that controversial note, we end our discussion this Thursday. And of course, I thank you very much to my guests for a robust and lively discussion, I would say. Thank you very much for tuning in. Of course, we have our guests this evening, labour lawyer Natasha Moni, media specialist, of course, Lance Classen, and of course, a media lawyer as well, Okryrebea Ampofo-Anti, there joining us this evening.